Yeah, good. All right. Is this a master?
This one is the Boston Convention. Much different year this year, 2020. Pardon me. I know, I should get an award or something. She got out of all the gens.
No, I know. I just took one over. Justice or something.
Oh, yeah, last time. Not just settleable case.
It's a simple case.
It was
So
settleable
it's
case.
a simple. I mean, I would try to push her into 50-50.
And he mentioned a consultant. But here's the thing, my understanding is just my understanding. But then, back in this line, it can be 50-50 only if the grandparents are still
Oh,
the
that's,
caretakers.
yeah, I know. That's where she's.
And it's like, what are you
That
talking
doesn't,
about?
but the grandmother, that's not the law.
It isn't. And Judge Sonia did this already. She did it early on, and honestly, I think she did it to try to get them settled.
I know.
You know what I mean? Here's the order. This is what I'm gonna do. You're not
And if it
moving.
doesn't work, you can modify it.
Yeah, the financial, they're young, so the financial stuff should be pretty straightforward.
I mean, she's been in the house a couple of years and we've been sharing 50-50. I'm not sure
No,
what
she just needs to buy it up, and figure out those
whatever-
logistics, but I
whatever we
think,
can do.
so, and she just got the increase in child support, so I think that was part of it. You have, here's your increase in child support, and now you can go to the bank. No?
I mean, to me, it's a.
She come to you asking, I mean, I know you can't really tell me this, but the main impression of many of these cases that happen is
Court, all rise, please. Carry. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, defendant for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning. Welcome to the Appeals Court. I am William Mead. With me today are Justices Desmond and Hand. Will be the panel for all three cases this morning. If you haven't been here before, each side gets 15 minutes. You needn't use all of your time. We have read everything. My best advice is to get right to the point. With that, I'll call our first case, 2022 P44, EA versus AC. Ms. Ramos, welcome.
Good morning, Your Honors. May it please the Court, Melissa Ramos on behalf of the defendant, AC. I've spent a lot of time thinking about how I want to come up here and present this question to you. And I think that ultimately this case is about how many times the defendant can be repeatedly hailed into court and forced to defend against a new order when he hasn't engaged in any new harassing behavior.
Isn't that a legislative question in this instance, though?
Well, this court has the power to kind of put a gloss on the statute, giving guidance down to the trial court to interpret the statute and how it should act in the face of a case in this procedural posture.
But am I correct in understanding that your interest in putting a numerical limit or changing the standard that applies to subsequent order requests is to protect the defendant and to provide finality for the defendant? Is that correct?
Yeah, so not necessarily a numerical limit, but certainly something that does protect the due process rights of the defendant, because as the statute is written, and in conjunction with especially recent case law, specifically Yasmin Y, there's an inconsistency in the way that a hearing after notice versus an extension hearing is handled.
Why doesn't the hearing process itself provide the protection that you're talking about? Because it doesn't. Well, let me step back for a minute. What's the difference you see between the ex parte and the hearing after notice requirements?
So, as the statute is written, the definition of harassment that I'm particularly focused on here is the one that's at the end, the third prong essentially, where it says harassment is an act that constitutes a violation of, and then the enumerated statutes. So its logical conclusion, the way the statute is written, is that in a hearing after notice, all the plaintiff must prove by a preponderance of the evidence is that that crime occurred. And so in the instance of a conviction, that can always be proven, no matter what. There's nothing the defendant can rebut to disprove that.
So suffering from harassment means harassment is taking place. It doesn't mean that there's any requirement that the plaintiff show by a preponderance the suffering from portion?
Not in a hearing after notice. But in Yasmin Y, this court stated that at an extension hearing, you don't have to rehash the facts of the initial facts, but the plaintiff must show a continued necessity. And so in its logical conclusion, when you read the statute and Yasmin Y together, let's use Yasmin Y as the example. If Quashan Q had been convicted of what Yasmin Y accused him of, then Yasmin Y could let orders lapse and then come back into court and only seek the order based on the conviction. Whereas if she continues with the extension, she has to continue to show necessity. So essentially, these two read together encourages a gaming of the system because it lowers the burden for that hearing after notice.
What if the same requirement, if I understand correctly, you're saying that at the hearing after notice, a different standard is applied than to an extension subsequent?
That is what it appears when you read the statute and the case all together.
What if the same standard applied across the board? What if the requirement was to show a need for protection from harassment at the order after notice? Wouldn't that be sufficient?
So I do think that's mostly what I'm getting at with a showing of good cause, necessity. You know, the trial courts are in a great position to make those determinations, and it does provide an additional kind of factor where the defendant can, in fact, rebut that need. Whereas if it's just a conviction, the defendant can never rebut because the plaintiff doesn't have to show anything else.
And it's your view that a plaintiff coming into court and saying, I'm seeking a harassment order against a defendant who is accused of indecently assaulting who is convicted of indecently assaulting and battering me, must be granted the order under the statute?
Under the statute, it does not appear that the judge has any discretion. And I think that actually goes to a point in Yasmin Y that specifically points out that the judge should use his discernment in an extension hearing as to the necessity. And so if we're going to ask for judge's discernment at an extension hearing, then the judge should have that opportunity to engage, collect evidence, first and foremost, which wasn't done here, but engage in a question of whether there is necessity or good cause.
So jumping ahead for a second to the hearing portion in this case, is the fact that the defendant was being released from incarceration imminently insufficient, in your view, to demonstrate that there was a need for protection from the harassment that the statute has already defined as the offense for which he was convicted?
Yes, because in the instances where a time period has elapsed between kind of the initial harassment and when a new order is sought, in my brief, there's a long list of cases in which a new order was granted and appeal was, the new order was upheld, and it's because there was a direct contact between the defendant and the plaintiff, either through themselves showing up someplace where the plaintiff was, or having a friend or a private investigator drive by the plaintiff's home or place of work. And so a positive parole vote, not even a release, there's no direct communication between the defendant and the plaintiff for that to be sufficient here, especially where we have this lapse of time. So I just do want to note a little bit more that, you know, Yasmin Y is in a different posture because it's an extension hearing, and here we're dealing with an initial order. And I would just like to point out that
So when you say an initial order, you mean that the hearing that was conducted was, in your mind, a request for a new 258 order?
yes, it absolutely was. This was not an extension hearing. This was a completely new order with a new affidavit that took place, 6 years or about 4 years after the initial order back in 2016 that lasted till 2018, that expired. So this was a completely new order several years later.
Can I ask you, you raise issues related, as you've mentioned, the good cause and latches and due process. Were any of those claims made below?
So the claims that were made below were a general argument against a new order issuing in the wake of the facts and the circumstances of the last order.
But were those specific issues raised below?
The specific words were not used, but the context in which the argument was made was certainly in the exact same context as it was
To be
raised.
focusing on issue of preclusion or res judicata.
That was initially kind of the gloss that was made at the initial hearing, but again, the context and the way in which the argument was made was similar, almost exactly the same as to how it was raised in the brief. And so I would say that the issues are adequately preserved because it gave the lower court judge enough information to understand what the defendant's argument was.
Well, I mean, when you're adding a requirement that's not in the statute and you don't articulate that to the judge, how is he or she be able to discern that, let alone a due process challenge?
So in the lower court, the argument was focused on initial order, lapse, new order, and kind of deficiency in the argument that was made. And I think that, the judge, we obviously cannot foresee the request from this court to give guidance to the lower court, but there was an idea presented to the judge that what was before him was not enough because we had already been through those exact same facts before. And I would just like to point out that at the lower court, the judge was dealing with very little information. It was a single sentence affidavit, a question posed to the plaintiff, do you want me to extend this order? She says yes. And then the very probable inference that the judge relied on the conviction. And so even with all of the arguments about good cause, preponderance of the evidence still requires facts to be gathered. And here, there was no gathering of facts. The plaintiff didn't meet her burden.
Didn't they have evidence of his conviction, right?
Yes, so if the way that we read the statute is that a conviction is enough, then yes, that is what happened. And the order was granted solely based on the conviction, which, again, that's an inference that the judge relied on the conviction. It wasn't even outwardly stated that that's what he was relying on to grant the order. But that is also part of why the request here is to provide a gloss on the statute that gives guidance to the trial court judge.
Was this the trial court judge?
Excuse me?
Was this the trial court judge?
The trial court judge was the trial judge for the convictions. Yes.
And so isn't there some inference that he was relying on his memory of the trial itself?
Absolutely an inference, but not the stated reason for granting the order. So we really don't know the basis that he granted the order. That's the inference that can be gleaned from the statements that he made prior to granting the order. So just in closing, I'd like to say that the statute as written infers that a conviction is enough for an initial order. But in the specific posture of this case, especially where we don't have a very sufficient record below, it really does encourage gaming of the system because it lowers the burden and it encourages the plaintiff to allow an order to lapse and then seek a new order at any given point in time in the future, just on the basis of conviction alone, without needing to show any other cause. And I do want to point out here that the order in this case has once again lapsed. It was not extended at the end of last year, and so we could very well be in this same position again in 1, 2, 3, 5, 10 years.
Is he on parole now?
He's had a positive parole vote.
Oh, he's not out on parole, though?
It's unclear.
Oh.
Has he had any alleged violations of
None.
this order?
None. And his parole conditions include a stay away, no contact for the 5 years of his parole conditions. So if there are no further questions, I'll rest on my brief. Thank you.
Thank you. Thank you very much. We'll take it under advisement. The next case is 22P 370, Raynaud versus Raynaud. Ms. Dargy.
Good morning. May it please the court, my name is Ann Dargy, and I represent the husband, who's the defendant in this case, and the appellant, Roger Raynaud. Understanding that the court has reviewed the briefs, I'd like to turn to the first, and I think most critical point in this case, which is the award of alimony. My client was ordered to pay alimony to the wife in the amount of $150 per week. That award has no basis in the findings of the court or in the law. Starting with the court's findings, the court made a specific finding that, and this is on Record Appendix page 17, the court determined the parties' respective incomes and determined the parties' expenses. The court determined that the husband's ability to pay his expenses isn't possible. His income doesn't cover his expenses, and yet made an award of alimony without finding that he had the ability to pay. She also made findings with respect to the wife's income, finding that she makes $350 a week and that she receives $50 a week from her an adult child who lives with her, and determined her expenses to be $409 a week, which would have only, the deficit to cover that would have been approximately $9 to $10 per week, and yet made an order of $150 per week in alimony, again, without a finding that the wife had any demonstrable need.
Can he make findings based on a difference in lifestyles that they have post-divorce?
Is the question, did the judge? Because they were...
And can he? She, excuse me.
No, well, the court certainly could have, but the court didn't. The court didn't make a finding that there was any need from the wife's perspective to have an increased amount of income in order to have a similar lifestyle to the husband. In fact, specifically didn't make those findings, and I think it's important to note in the case law, and this was noted in my brief as well, that even if the court had made such a finding, that the wife isn't entitled to an alimony order that would then be at the detriment of the husband. I mean, the simple disparate lifestyle, that in and of itself doesn't create an entitlement to alimony. I would argue, in fact, that there is no entitlement to alimony in our law. In any of the law dealing with alimony, particularly 48, the Section 48 continues to stay and be very clear that alimony is defined as a payment to a spouse who is in need by a spouse who has the ability to pay. And again, there's actually a finding to the opposite, that the husband in this case has the ability to pay alimony. And there are some other factors that were part of the evidence and part of the record at trial that weren't considered, such as the husband has a minor child in his home from a previous relationship that he is required to maintain. And I think that must be considered. This child was in high school at the time, that resided in the home, and this child's sole source of support was the husband.
Does he have more than one child?
No, Your Honor, one child.
The child is 18, though.
Right, the child was unemancipated at the time of trial, and I believe is still unemancipated. There's one unemancipated child. I believe the husband has other adult children, but one unemancipated child that resides in the home.
Was there some question with respect to his financial disclosures?
Not that he was is a W-2 employee, but also collects overtime, some overtime, but also collects unemployment as his work as, you'll have to pardon me, I don't know the details of it, but it does relate to, it's seasonal work that relates to laying asphalt, things of that nature. So it isn't something that's done year-round, so he did typically collect unemployment and worked during the other months, and that was discussed that had happened and had occurred throughout the marriage.
And all those figures were put forth by him?
Yes, Your Honor. I believe the finding that the court made included both the income that he was earning from the from his job throughout the year, as well as the actual employment, as well as the unemployment. And though that information was both given to the judge and I believe considered in her determination of his alimony of his income calculation. And that's on Record Appendix page 17 with respect to her actual findings regarding the parties' income, because there was an attribution of income to the wife. The court used her typical hourly rate, and rather than have her working part-time, had her calculated that on a 40-hour basis, which we do, to some degree, find to be not a sufficient amount of attribution of income. But I think even setting that argument aside, which is briefed, but setting that argument aside for this particular purpose with respect to alimony, it still doesn't indicate that the wife had any need. And actually, there were a number of other factors that the wife didn't, or that the court didn't put in the findings that also suggest that alimony isn't appropriate. The wife was able to accrue substantial savings. There was testimony with respect to the amount of money that the wife was able to have in her nightstand. At one point, she had up to $3,000 in her nightstand, and she was continuing to sort of manage some of these savings by putting cash in the nightstand. There was no evidence that husband had the ability to do that.
I'm looking at page 17. Is there some figure in there as to how much the husband was collecting for unemployment? I don't see that.
That was the combined amount, Your Honor. When that finding that the court made on page 17, the 107.3 per week, she indicates that he collects unemployment and that his income was the 107 per week, which I believe is an average. Again, that's me doing the math. I certainly understand from Your Honor's perspective that the court doesn't map out specifically where that finding came from, but my belief...
Did he provide documentation of his unemployment compensation?
Throughout the case, I would suggest that throughout the trial that was provided.
Just a yes or no would be good.
I'm sorry, Your Honor.
Just a yes or no, please.
On the day of, I'm sorry, if you, one moment I can. The unemployment was not listed on the financial statement that was submitted at trial as he was working at that time. So there wasn't a presentation of the unemployment as he wasn't receiving it at the time.
So there's unaccounted for income that we know about, right?
Well, no, Your Honor. There was testimony about the income, and there was about the unemployment, and that had occurred throughout the litigation. So when the court entered orders, the court has access to the financial statements that were filed throughout the divorce process.
I thought you just told me the financial statement did not include his unemployment income.
So the one that I provided to you, Judge, was from trial, was the financial statement that was submitted on the day of trial, which was October 25th, 2021. That particular financial statement does not have unemployment income on it, as he wasn't working it at that time.
Get it. So which one does? Point to it in the record, please.
I don't believe that I provided a financial statement. I'm sorry, beginning Record Appendix 9. You'll see on this, there was a $704 a week is what the unemployment compensation was at that time. And he was also at that time receiving $100 a week in child support for the minor, which had been discontinued by the time of trial. So with respect to that, my calculation, my understanding of the court's findings, the court had awareness of the unemployment calculation, and I believe that the court would have certainly had that available, had those numbers available. There was testimony with respect to the fact that it was a seasonal job and that he collects unemployment. That having been said, even with the unemployment, I would suggest that there would have been challenges, and certainly while he was only collecting unemployment, an almost inability to even meet his own expenses. And what he does, and he's testified that when he's unemployed and collecting unemployment, that he utilizes credit cards to meet those expenses. He had paid for food, he had bought groceries and those kinds of things on his credit cards.
And the wife does the same?
Well, the wife's testimony was that she used her credit cards for her own expenses, that she used them with respect to her credit card debt, that it related to things for herself, as compared to the debt that the husband accrued, which was for the management of the household during the marriage, that he was buying food for the children. There were a number of children living in the house in different configurations throughout their marriage. Both parties have children from previous relationships, that he would buy gifts with the credit cards, he would buy a variety of things for the parties. There was no suggestion in this case, truthfully, for both parties, there was not a suggestion these parties lived a lifestyle that was, potentially above their means to some degree, but it was a very modest lifestyle, and the court made that finding. These were not parties who went on vacation or had, major spa expenses, plastic surgery expenses, those kinds of things. I mean, the parties were at home, and I think the piece that may be with respect to that is worth mentioning is that the court found, and there was a substantial amount of evidence, that the wife had a significant alcohol problem, that she had a history, a criminal history that related to the alcohol problem, but we didn't, and continue not, to the degree that that caused a financial strain on the parties. I would suggest that that was likely managed through the wife's credit cards. There wasn't any testimony that the wife's credit cards, or any evidence that the wife's credit cards were used for the family, that they were used for her own expenses.
Do you want to talk about the durational limit?
Yes, Your Honor. I'm inclined to suggest that the statute is straightforward insofar as the number of months that the court found. That was on the beginning of, in the court's findings, that we don't contest the number of months that she found, but we would contest that she then entered an order that has husband paying an additional 11 months of alimony. The court found that the marriage was 100, for the purposes of alimony, the court was expressly stated 110 months, and that's, the statute would suggest that that's 60% of those months, which is 66 months. And the actual limit that the court prescribed was 77 months. And there isn't any indication in the findings and the rationale about why there would be an extra almost year of payment of alimony when...
Well, I think the wife says that they cohabitated before marriage.
I certainly understand that there may be some arguments about why, and some speculation. I would suggest it's purely that, speculation. There isn't anything in the record there wasn't anything in the record, but certainly nothing provided by the court to indicate what the basis...
Found 110.
...for such a yes, I can point that.
No, I got it.
Okay. That the court found that was the number specifically for alimony, and then did attach...
I'm sorry to interrupt. He would have had to find more than 110 to get to the 77 months.
Correct, Your Honor. Well, and I think that, we acknowledge, and I acknowledge in my brief, that there are cases where a court will deviate from the statutory durational limit, and I'm not suggesting that's not appropriate, but it does have to be done with findings. There does have to be some indication about why there would be a lengthy period. And in this particular case, and we do make some arguments with respect to the asset division, which I will rest on my brief, but I think in this particular case, there's no suggestion that wife had access to a significant amount of money. Husband had to pay a significant amount of cash to the wife fairly quickly, within 90 days after the divorce, to cover her equitable division of the marital home. So sometimes, and in some cases, a court will deviate from an alimony durational limit to sort of cover what could be a disparate division of the assets. It just isn't the case here, and there's no suggestion in the court's rationale that it intended to do that. And in fact, the court is quite clear in its judgment that the alimony will be the statutory durational limit.
Can I ask you just one asset question about the trailer? And you claim that she should have had the asset valued at $15,000 rather than half that, right?
Yes, Your Honor.
But she didn't gain that second half until they were separated. Does that make it a matter of discretion for the judge to consider this asset gained at that point?
Well, I certainly recognize that the court has a great deal of discretion when it comes to the division of the assets. I don't deny that. My concern with respect to the asset division was there seemed to be sort of a lack of recognition, or perhaps an misunderstanding of the record as far as when that asset was obtained, that the asset was obtained prior to the party separation in 2019. And so...
Well, half was.
Percent share.
Half was, yeah.
I think that...
Cousin gave her the other half for $1 after they separated.
And I agree that there was that potentially, yes, Judge. I think the issue is more that the way that the court appeared to construct the asset division seemed to ignore the fact that that this asset was obtained prior to the marriage. And so the concern again, and the similar concern with the
Credited that,
alimony.
that part. He credited her with half of it that she obtained before the marriage.
But I think that goes to the overall. I don't think it was a dollar-for-dollar credit, and it also didn't take into consideration the substantial amount of marital credit card debt that the husband kept while the wife, it wasn't, I didn't, from the record, understand why the court would have done such a disparate impact of the division of the equity without more findings.
You also challenged the attorney fees.
Yes, Your Honor.
And so he had a bunch of cars that were in his name,
Yes.
and she had to get counsel to kind of tease out about those cars. He hadn't really readily disclosed those cars. Is that fair to say?
Well, it is fair to say that he didn't disclose them in the first instance, but he paid attorney's fees during the litigation for that issue. And so the second set of attorney's fees, there's no basis for, because he was already penalized for not, and interestingly enough, he was penalized for not disclosing those cars, but notably the court did find that those cars were not anything that was part of the court removed them from the marital estate because the parties had never utilized them, had never put assets toward them. They were all essentially owned by his brother. And it's the record, I think, makes clear that from
But they didn't know that until they discovered them.
Well, but I think, yes, Judge, but I think parties who are not sophisticated, which is the case here, I think the belief and the understanding was that those were the brother's cars, not the party's cars. It wasn't intentionally misleading. It was a true belief. And we had the brother, as you'll see from the record, had the brother testify about his involvement and use of those cars.
All right, thank you.
Thank you.
Mr. Smith.
Good morning, Your Honor. I'd like to address the question that was raised about this unemployment issue. I think that's a very important question.
Hold that microphone closer to you.
I'm sorry. Can you hear me now? I'd like to address the unemployment question
Okay,
that
go
Your
ahead.
Honor raised, all of Your Honors raised. Mr. Reno, the record reflects that during
Just a second.
2020...
Can you start the clock for him?
Pardon?
Just a second, he hasn't started the clock yet. Thank you.
Mr. Reno, during 2020, only collected unemployment. That's reflected on their financial statement that was submitted at trial, which is RA2. It's the financial statement, the trial financial statement of Mr. Reno, RA218. Strike that. RA2, it's not 18. I just had it. I have hers. So the financial statement that he submitted at trial, which is in his appendix. Well, I can't find the paperwork right now, but what I can tell the court, the one that he had at trial is RA224, RA224. And in that, there is no unemployment reflected whatsoever for the trial date. What's attached to it is a 1099 on RA231, which is a unemployment for 2020. And in a footnote, they reflect that all income, footnote 3, which is RA230, all income for 2020 is unemployment benefits from the Department of Unemployment Assistance supplemented by federal COVID. So he didn't work at all in 2020. He did work in 2021 when the trial took place, and if you look at RA224, you will see The gross weekly income reflects $1,073.54, which is exactly the sum that the court found that he made in its findings on RA 117, $1,073.54. So what I'm saying to you is that the man did not reflect any of his unemployment for 2021 whatsoever. He put 0 down on his financial statement, which is a significant issue from our perspective. I don't think the judge made a combination of unemployment and gross income, because there's none listed on his financial statement. It's a 0, and that's very clear. The other issue is the financial statement that was submitted by Mr. Rayno averages income. I don't know what that means, averages income, and it's in the footnotes again. This is the average of income. This is the average of bonuses. I don't know what that means. Why don't you average unemployment too during the year? Because you've testified that for 2 to 3 months every single year you do not work and collect unemployment. Average that as well. Give us an honorable financial statement. So I don't know what his income is. My client clearly never worked more than part-time. She was a 20 to 25-hour worker. She worked at cerebral palsy. She worked in the kitchen. She's worked as a I don't know what the exact term is, but she cleans in a motel. And she works there on her knees, which are very problematic, and she works less than 25 hours a week. The judge attributed her up to 25 hours a week underemployability.
And you say in your brief that that's an error, but did you cross appeal?
I didn't cross appeal, and I said it was harmless because she needs the money, and my client wished to proceed the way it was. She needs the dough. She lives in a trailer. She has a very sparse lifestyle. I didn't cross appeal, but to me, I called it harmless. I just think it would be to your benefit if you spent time on other issues then. All right. So let me talk to you about duration for a second. All right. It's clear that any court has discretion to extend the length of marriage based on a common household. There was a stipulation in this case. The parties started living together in 2007.
If they're going to extend it, do they have to explain why they're doing that? I think that's the quarrel.
Yeah, and the most I would say to you, Judge, here is that probably should have been done in this case. I would again say it's harmless. It should have been explained. In fact, but I will say this, if you do the math, I could make an argument that the court didn't do it because they found the property division commenced from the date of them living together in August of 2007. That's how the judge determined the property award in this case. She didn't do it in the alimony. I'm not sure why. Maybe she picked a number. I think...
So you'd be speculating. So when you say harmless for the wife.
Harmless for the wife. Harmless for the wife. I mean, what I'm saying, though, is it's clear what the judge did do, what my sister didn't reflect. She did make a finding that the parties both contributed to the marital relationship.
But the judge also made a finding that the duration of the marriage was 110 months, which is 9 years, and 2 months, which is less than 10 years, which puts you in 60%, right?
I understand.
So that's 66 months, right?
Correct.
Not 77.
Not 77. It's a mathematical error. And again, most I can say to you is this. If the court had went back, and I'm speculating now, to the time when they were living together, it could have been 12 years and 2 months, because the court didn't do that either. They did that in the property division. So it could have been longer. They
could have been, but as Justice Desmond just astutely pointed out, you have to have findings to explain that deviation.
I have the opinion the way it's been given to me, and I don't know what to say. I do have a finding that on page RA 19 that both parties contributed to the maintenance of the home. Husband primarily paid the mortgage, taxes, homeowner's insurance. Wife would assist in paying utilities for the house. Okay, so that's a factual finding. It doesn't establish what Your Honor is talking about in terms of how she calculated that number. I'm not sure where she came up with that number. I honestly can't tell you. I just don't know.
Can I ask you about the alimony? The wife's, according to husband, the wife's income is $350 a week, and the daughter contributes $400 a month, which the husband says accounts for all but $9.76 of her claimed weekly expenses. And he's paying $150, which is roughly $140 over what she needs.
All of the evidence reflected that wasn't her income. The evidence reflected her income was $230 a week.
The judge, she attributed income.
She attributed income to her.
That's how we got to the $350. That's a finding of fact, right?
The attribution, it's a court's finding, yes.
Okay.
Whether it's correct
and she also found that the daughter contributed $50 a week or $400 a month.
Correct.
And so when you do the math, husband says all she needed was an extra $10 a week.
But it's not real, with due respect. She was attributing money to her that she's never.
I don't like math either, but
she's never earned that kind of money.
But again, you didn't claim that the finding was clearly erroneous.
I understand that, Judge, but I mean, you could send it back and we could go through this process. Again, I understand.
I'm not saying how we're going to decide anything. I'm just wanted to know if those numbers are correct.
Those numbers
based
are
on the findings.
Those are correct, and the court, with due respect, her findings were a little bit confusing to me, okay? I'm not questioning that. But from an equitable perspective, which is all I'm arguing in this practice of domestic law, in terms of fairness, I don't think, that's why I called it harmless. I don't think she did the Emery versus Sturdivant test. I don't think she found that there has to be some reasonable effort. There was no information about training, which is right in 53A. So, yes, the court had some issues. I don't question that. I think there's some inconsistencies. I can't argue around it mathematically, but from an equitable perspective, I think that the $150 was fairly low, and there was significant need and capacity to pay, and that's the bottom line here. Any other questions or any other issues?
No, thank you.
All right, thank you.
Thank you both. We'll take this under advisement. What's the word I was looking for?
Yeah, I'm going to give it to you, outside. Take that.
Our last case is 22P303, Department of Children and Families and Another versus Mother. Ms. Spanos.
Good morning, Your Honors. May it please the Court, I am Attorney Diana Spanos, and I represent the appellant mother. To start off with today, I want to acknowledge to the panel that I am aware this is a factually difficult case for my client. We're looking at an uphill battle, and I know that. But I want to point out the judge largely concluded mother's unfitness based on three primary things: allegations of substance abuse, that the court concluded mother failed to recognize or acknowledge, mother's alleged untreated mental health history, and allegations of domestic violence. But mother hopes to show that the key findings or the basis for the lower court's determination of unfitness do contain some crucial mistakes, and together with arguably a lack of specific detail. And she prays that this will and should give this court some pause to reconsider. Regarding substance abuse, I'd like to take a minute to point out some of the medical expert testimony that was in the record. In Volume 1, page 55, Dr. Semmel, who treated mother for almost 2 years, gave her opinion that mother tested positive during those times due to being exposed through skin-to-skin contact to fentanyl, not through use.
Did the judge credit that?
Well, no.
The judge wasn't required to credit it, was he?
The judge did not credit that. But in Exhibit Volume 2, page 119, Dr. Semmel said that mother's norfentanyl levels were not consistent with fentanyl use, just exposure. Volume 2, page 109, Dr. Semmel had no concerns that mother was using fentanyl. Volume 2, pages 187 and 189, Ms. Schick, who was the final social worker on the case, drafted the assessment dated January 21, which is 3 months before trial. And she says that mother has consistently provided DCF with screens free of all substances not prescribed. In fact, when mother left the father's home in April, just before the child's birth, there were no more positive tests for norfentanyl ever in the record. In transcript 1, page 393, the social worker, DCF, testified that mother attended all of her appointments for Suboxone management and tested negative for all substances not prescribed. Volume 2, page 28.
Was it your position that mother did not have a substance abuse issue? Was that your position?
No, mother had a prior history, but once the petition opened, she did not test positive for any substance not prescribed after the birth of the child. Volume 2, page 28, the child was born positive for medications that were prescribed to the mother. In finding of fact 110, the judge found that mother denied the child was born with a substance exposed to substances, but arguably the court was referring to mother's adamant testimony that the child was not born exposed to fentanyl. Mother was acutely aware that her own medications did impact the child. Her own testimony on page 259 of the transcript, she said, "I've been concerned about the medication that I was on, how it was going to affect my child. I constantly asked the doctor, every doctor in there, how will this affect him physically? Is it going to affect him mentally? Will he have problems later on in life?" And according to her, all the doctors said they couldn't give her a definitive answer. There weren't enough studies. If you look back at, excuse me, even the earlier records regarding her firstborn child, that child, she had been in a car accident while she was pregnant with that child, and there was recommended medications that mother refused to take because of her pregnancy. So mother's position is that the judge, she didn't test positive for substances for 2 years before trial. Regarding mother's, excuse me, mental health, mother does have a significant trauma history. She's been involved in mental health services for quite a while. But her trauma history oftentimes will compromise her presentation and unfortunately challenge her likability. That being said, DCF records indicate that mother was fully compliant with her mental health services, specifically through December of 2020, and DCF was comfortable with that. Exhibit Volume 2, page 187, again, the assessment that is drafted by Ms. Schick, the last social worker, and was effective from January of 21 through July of 22, which is, in fact, after the trial ended. That assessment states that mother consistently provided DCF verification of her mental health treatment. Even after January, Ms. Schick was able to speak with mother's therapist, who reported that mother was compliant. but the department wasn't satisfied with the limited release that was given to her.
You believe that mother was in need of services. Let's start with that.
Mother, yes, mother needed services. Mother's been engaged with services, I think, since she was a teenager.
And can we point to anything in the record that shows that mother has benefited from the services?
Well, I would say that the August incident of domestic violence between the mother and father.
Well, I'm not sure whether that was a domestic violence incident or if
Well,
that reflects more on the mental health issue. It
And,
seems
and
that
I
they're getting
appreciate that.
double credited somehow in those areas sometimes.
I think that,
We complain that she has a domestic violence history, but then a lot of it's discredited because of her mental health issue. And so it seems like it's being credited against the mother on two levels. Once because of the domestic violence, but then we say, well, we don't believe that because her mental health issue was affecting her recitation of the facts or her memory of the facts or what have you. But more to the point, my question is she benefiting from the services? And if so, show me where on the record.
well, I think in the record, you won't find that there are any outrageous incidents of anything after that incident. I mean, from then on, mother, for better or worse, maintained a straight line. She continued on. Actually, the record shows she became very involved with domestic violence services.
When was the last time she visited the child?
Oh, she was visiting. There's actually references. And you know, what I think is really unfortunate, and I know Mother's trial counsel really wanted to call her first social worker, who had much more experience with Mother and with the child, had been to Mother's home, had, you know, seen them visiting together. Unfortunately, she passed away very suddenly, and, you know, in fact, in the middle of the trial. But if you look at her records, and again, it's the assessment, I believe, in December that, excuse me, I'm thirsty, that her visits were great. And I believe in her assessment, she says Mother is very engaging with the child, is always prepared for visits, brings her belongings. I know Child's Counsel raises an issue in her brief that Mother wasn't controlling the child at visits. And there was one visit where Mother testified at trial, she saw the little boy fell 3 times. And Mother testified she thought it was because his legs were bow-legged, that he might have some sort of a physical detriment that was compromising him, and he wasn't putting his hands out. Actually, the first social worker said Mother is pretty good and in tune with child behaviors. Now, she was diagnosed, I've actually got the, Mother did have some physical complications that really arose in January of 2021. She suffers from endometriosis, was in a lot of pain. She was involved in treatment at the Dana-Farber Center. She brought in a doctor's note, excuse me, showing that she had missed an appointment, or a visit, I'm sorry, because of that medical condition. But getting back to your question, yes, she visited. And the problem that I felt, and had I been trial counsel, it was very frustrating. The second social worker never saw Mother with the child at all. The visits were being held at a visitation center. She never saw Mother with the child, and yet she was her ongoing worker. I find that pretty outrageous.
So Mom consistently visited the child, is your position?
She was visiting consistently, and then when the visits were reduced to twice a month, which was around,
When they changed to adoption, right?
I believe it was, the goal changed in November, I think.
So has she visited consistently since then? Let's start there.
No, she missed one or two visits, I believe. One was for when she was at the hospital, and she did provide the worker with a note. And I believe there was another one, and I don't know that answer.
Does Mom have a stable home?
Mom had one incident in February of 2020 2020, I believe.
Do you know, does she have a stable home?
She's living with her father.
Say that that's a suitable place for the child?
Well, mother said at trial, as she testified, she'd be willing to go into a shelter placement or, whatever. She was willing to move. She did consider her father as support. The record refers to him as another domestic abusive relationship. They did have a problem in February of 2020. But again, I go back to mother's trauma history. Sometimes her presentation, she will say things that are inflammatory and then immediately regrets them. And I think that's, what.
Child has some special needs?
I think the child has done very, very well.
And who's that a credit to?
I'm sorry?
Who's that a credit to?
Well, I mean, he got early intervention services right from the hospital, which mother would have done. She talked about it. She wanted it done. But, I mean, mother wasn't able to care for him 24/7, so it wasn't mother that provided that. The last thing I'll try to also address is the domestic violence piece. Well, actually, before I move on, the psychological evaluation was something that the department wanted. They didn't recommend it until, I believe, October of 2020. And the worker who passed away said she made a referral. Mother went to her own treatment providers, found out she couldn't get it done there. And again, this is during probably the worst parts of COVID. There weren't a lot of services available. It's really not clear beyond whatever the written record says that the first worker referred mother to an evaluation. Ms. Schick said she called them in March of 2021 and knew that mother was having a hard time with the intake. But beyond that, Ms. Schick made no further referrals. So, I mean, I agree with the judge. It might have been helpful had there been an evaluation done, something more concrete to rely on, but it didn't happen.
How much of the absence of information on that particular point has to do with mother's failure to provide complete releases? Any of it?
Oh, I don't think any of that. No, I think honestly, mother she had problems with technology in other portions of the case. And, again, this was COVID. You weren't allowed to walk into the buildings and get help with anything. It all had to be done online, and she couldn't do it.
So right now, mom's not financially stable, right? She has zero income?
No, she gets some assistance.
And she lives with her dad in a one-bedroom.
Yes, which the first social worker had visited, and in the record it indicates that mother was completely prepared. She had a baby's room and belongings, or an area for the child all set up. But it wasn't mother's, she wasn't saying, I have to live with my father. She said, I will go, if there's a more suitable place, I'll go.
Well, did she investigate? Is there a more suitable place?
Oh, for permanent living?
Yeah, with the child. I mean, did she say, I've got a alternative housing?
I believe her testimony in the record was, if I can't bring him home today, I will look and find a place that is appropriate. But I mean, arguably, if in the record, the first worker had gone out to her father's home and saw that it was presentable. The concern was that they had had an argument in February 2020, and
Mother and father. Mother and her father.
Mother and her father, which they both expressed remorse for afterwards. And I was going to address, I realize I'm very close to running out of time, but I will leave it at that and rest on my brief. Thank you.
Thank you. Ms. Braithwaite.
Good morning, members of the panel. May it please the court. I'm Kristen Braithwaite, Assistant General Counsel for the Department of Children and Families, and I'm here today asking you to affirm the decree issued by the lower court. The decision reached in this matter was correct. There was abundant evidence that mother was unfit, that her unfitness was not temporary, and that it was in the best interests of the child that her parental rights be terminated.
So it seems as though there's a lot of talk about the domestic violence that's in mother's life,
Yes,
and a lot of talk about the mental health that she suffers from,
yes.
PTSD and anxiety and the other. But it seems as though in some of those instances, we call it domestic violence and then suggest that that didn't happen at all, and that was kind of a, I don't want to say a figment of mom's imagination, but it was her account of what happened wasn't credited, and in some instances, the father's account was credited. But yet we call it a domestic violence incident. So, but it's not a domestic violence incident, right?
Well, I think that there were both, and I do agree that the way the findings read at times it's not clear, but I think I could highlight some findings the court specifically made indicating domestic violence did exist, which were separate from those where the court found that it didn't credit mother's claims. If I may, specifically, the court found that during the care and protection, mother chose to remain involved with father, who was a violent drug addict, who she claimed sexually and physically abused her. The court found that despite the existence of restraining order, she repeatedly contacted father, voluntarily meeting up with him.
But the restraining order was premised on a false account, correct?
The restraining order was premised on an instance in which she claimed that he had assaulted her and raped her
Kidnapped
5
her.
times. Actually, the kidnapping was a different one. So she obtained the restraining order after an incident where she alleged that she woke up and her clothes had been removed and she was lying in semen. And there was not a specific discrediting of that instance, but there was an acknowledgement by the court that mother claimed sexual assault repeatedly throughout the trial, and that was evidence of. The court didn't specifically not credit that instance, but it did say, I don't take all of these for the truth. I take them as evidence of ongoing mental health. The court did find that mother invited father to the child's birth against the advice of all of her.
And so what does that say?
Well, it says that there was knowledge that father was abusive and that mother chose nonetheless to remain involved with him. And I think that was a big concern. I know that was a big concern that the court had, because repeatedly there would be opportunities for mother to separate herself and she would go back. Another finding in the record was that visits had to become separated, where mother and father couldn't be together because of domestic violence. And also at one point visits were prevented from going into the community as planned, again because of concerns for domestic violence. There was also a finding that mother sought supplemental Xanax from her psychiatrist due to allegations of concerns of domestic violence. There was evidence that father had a criminal history for violent behavior, but I do not believe that mother got penalized for the same instance in 2 ways, but I do think that there was an overlap between the actual domestic violence and mother's seeking out father in this volatile relationship. And the court expressed that by the time trial happened, mother had many instances of having claimed to remove herself from father and then going back voluntarily. For example, she obtained this restraining order alleging to have been raped 5 times and assaulted, and then in April, about 4 months later, she went to mother's home. And at that instance, the court specifically discredited her claims of having been bit, thrown on the bed, and assaulted. So that was an instance where the court discredited her claim of what happened, but was concerned with the fact that despite this existing restraining order, mother still went and sought out father.
The August incident, the court discredited her, is that right?
The August instance, the court did state in its findings that it was impossible to know with certainty everything that had happened, but there were a number of things the court did discredit. Specifically, mother indicated that she had been kind of kidnapped against her will by father. The court found that mother reached out to father, claimed that she had been raped, asked father to pick her up. Particularly concerning was that mother alleged to have been held against her will for days in a hotel, repeatedly repeatedly assaulted, repeatedly raped, repeatedly made to consume alcohol and drugs. And during that investigation, footage was uncovered that revealed mother shopping at times by herself and at times with father, and there wasn't any indication of distress or duress in either of those instances. So the court did find that those particular facts, mother's telling of those facts, defied credibility. I would also draw the court's attention, the panel's attention, to the similarities between some of mother's claims in that instance and in other instances. So repeatedly throughout the care and protection, when mother was found to have consumed alcohol, she would say, such and such a person forced me to drink alcohol. This wasn't the only time that had happened. And this is part of a larger pattern that the court made findings about, that mother had a pattern of not taking responsibility for her actions and blaming others. I think it's really important to note that the court explicitly found that mother was engaged in domestic violence, not just with father, also with a prior partner, and also with an individual she started dating separate from father during the course of the care and protection.
Domestic violence, you're saying?
Yes.
Also with her mother, and also with her father, and also with some strangers, right?
Yes. Yes. The court absolutely made explicit findings that mother participated in domestic violence. And although it speaks to the older child, she also made a finding that mother had engaged in violence inside her own home, which is uniquely harmful to children and would make it an increased risk for the child to be returned to mother's home.
With respect to the releases, there was some concern about a lot of the releases had expired, and then when she did sign new releases, they were limited releases. Did they ever point that out to Mom? That when was the first time they asked for a release after they had expired?
So I can point you to findings. Findings 92, 94, and 96 specifically. It would take me a minute, but I can give you the dates if you would like me to. But it was in those instances where mother was asked to help. Mother was told, we're reaching out to your psychiatrist. He or she is not responding. Can you help get us in touch? Can you help us understand what's happening? Mother refused. Similarly, that happened with the domestic violence counselor. We can't get in touch with them. We're trying to find out what's going on. We need to gauge your progress. Mother, in that instance, both refused to give information, indicated she was looking for a new domestic violence counselor, but refused a referral. And then finally, in finding number 94, the court found that the worker had repeatedly asked mother to return her releases, and she wouldn't. And so I think mother suggests that there was a burden shifting and that somehow the department, and I would like to be clear with regard to the burden shifting argument, the department affirmatively put in 44 exhibits, put 4 witnesses on the stand, and established that mother had a history. The court found that the department met its burden of establishing that mother had a substance abuse and mental health history. Mother was not without knowledge that information needed to be made available if she was making progress. The department repeatedly sought mother's help. They didn't just say, we think you have a problem and we're not.
We're going to hold it there. Thank you.
I'm sorry. Thank you, Your Honors.
Ms. Commandel.
Good morning, Your Honors. I represent the child in this matter, and I would ask that you affirm the lower court's ruling finding terminating a mother's parental rights. This case initially came in as what appeared to be a substance abuse case. The first 51A was filed within 2 days of the child's birth. There were concerns that mother was appearing high and that also father and mother were leaving at different times, sometimes at 3 o'clock in the morning, leaving the hospital, returning back to the hospital. The child was born on June 5th. Mother was discharged on June 10th. While she was discharged, she was leaving the hospital, coming back, at times with father, even though she had been advised, given the nature of their relationship, to not have him present there. She acknowledged that in her trial testimony. And then fast forward, the domestic violence really played more of a part in terms of mother's positioning at trial. She engaged consistently, as my sister has indicated, in these relationships. And part of that could be attributed, and the judge did find that that was due to her own significant trauma history.
And how does that link or support her unfitness to take care of child?
The domestic violence piece, and I believe it's cited within my brief, the impact of domestic violence on children, whether a witness or whether the subject of it, is exceptionally damaging. I believe it's custody of Vaughn. That's the particular case. But I think what the ultimate decision was, this case took a track that both parents appeared to be doing well, doing what they were supposed to be doing, unbeknownst to the department. They were continuing to engage in these, we'll call them incidents. Not all of them the police were called, but multiple the police were called. And the ultimate one was in August of 2020. The parents were, by all appearances, complying with their service plans. But despite, mother never obtained a psychological evaluation, but that became more critical following the August incident because she continued to engage in that relationship and not keep father at a distance, and that led the court to find that, and the department to find as well, that there was no mechanism to keep the child safe if he were placed in either parent's custody at that point. And so the case took that transitional change. That was in August of 2020. Fast forward a little bit to November when the department changed the goal. They were concerned about mother and father not being forthcoming or honest with the department. So the goal was changed. That led mother to become less available to the department. She seemed to be less engaged in the case. Her visits were changed, yes. Given the domestic violence piece, parents' visits were separated, and then they were ultimately held at a visitation center. I would suggest that, visitation center records in these cases are often admitted, with a certificate of service, and potentially sometimes people testify, but if positive evidence was contained in that record, I believe it should have been produced to the lower court for consideration. The social worker that testified and spoke with the visitation center, she testified as to what her knowledge was of the visits. Mother herself testified what she did during the visits and what she brought. Close to the end of trial, there were at least 2 to 3 missed visits by mother. And I sometimes, strike that. Part of the visit.
Those times the visits were 2 hours?
2 hours biweekly at a visitation center.
Twice a month?
Yes. And so mother had to call, make the appointment, do that. There were times where it was canceled because she didn't do that ahead of time. She does have significant medical needs that may impact her mobility or may impact her ability to care for the child, but that was not fleshed out at the trial court level, Your Honor.
And the child has special needs?
He has speech delay, certainly, but that was being treated with early intervention. If I'm allowed to go outside the record to answer what his needs are currently, he does not have autism, no. So at the time of trial, she had missed those particular ones, and then when she signed the limited releases, I would suggest that the department, given the incident in August of 2020, that really was the change maker of this case. They were significantly concerned for her mental health in terms of determining what services does she need, are the services she's participating in. She was fairly consistent with therapy and had a number of providers in terms of that she testified to. The department was unable to confirm, but that she testified to, but either not utilizing those or utilizing them and not learning from them and continuing to engage in those domestic violence relationships and interactions, I guess we can call them too. Some of them weren't relationships, they might have just been interactions, but I have nothing further other than to ask this court to affirm the lower court's decision, unless there's questions.
Seeing none, thank you. Thank you all.
Thank you.
We'll take it under advisement.
Thank you.
With that, I'd like to thank my colleagues, our law clerks, the timekeeper, and our court officers, and we'll stand in recess.
All rise, please.
Judge, want to